My name is Ron Cass, and I chair the Administrative Law and Regulatory Policy Group of the Federalist Society. I'm delighted to welcome you to our panel today on the breakdown of the public-private distinction. I know a number of you saw the word breakdown and decided that this panel spoke directly to you. For those of you who are here for the psychotherapy, that will come at the very end of the session. I was in the grocery store a couple of days ago and was sent by my wife to pick up a few things, and I noticed on the aisle right in front of me there was a woman with a small child, looked like about a 2 or 3 year old little girl, in the basket. And as they were going down the aisle, the little girl was grabbing things and pulling them into the basket, and the mother was putting them back. And at one point, she put back a box of cereal, and the little girl began to cry. And the mother said, "Catherine, it's okay. You'll be out of here in a few minutes. We just have a little time in the store." They went down the next aisle, and it was the aisle I was on as well. And again, the same thing happened. The little girl was pulling things off, and the mother put them back, and the little girl cried and started screaming. And the mother said, "Catherine, it's okay. You'll be out of here in a few minutes. Just hang on." And, after several different aisles, I was really impressed with the composure she had. And I went over to her and I said, I was really impressed at the way you dealt with your little girl, Catherine. At which point the mother said to me, "She's Elizabeth, I'm Catherine." There are times when things go awry and you're not quite sure what it is that is happening or how to deal with it. This past year, when we had the financial crisis and everyone decided very quickly something needed to be done, there was no shortage of answers as to what needed to be done and no shortage of different views as to how that would fix things. Of course, the route we took was that we began putting money, large amounts of money, into various companies and institutions. I remember in the film Austin Powers when Dr. Evil comes out of deep freeze and makes a demand, which he thinks is a great demand for $1 million, and then is informed that that isn't much money these days, and he, of course, adjusts it to $1 billion. And the government very quickly made the adjustment from billions to trillions. We used to think of billions of dollars as large amounts, and when the government is pouring hundreds of billions of dollars into individual companies, it kind of changes the landscape for us. Those of us who've been dealing with administrative law grew up with a system where you had private companies that were privately owned and privately run. And those companies were regulated to one degree or another by government, which was a separate enterprise. In today's world, we have a mixture where we have government as part owner and sometimes majority owner of companies that are also being regulated by other parts of the government. And the question we are asking today is, how will this work? What changes? What needs to be adjusted? We have a terrific panel of people who will speak to us this morning. I will introduce them all briefly, and then they will get up one after another. For ease of conversation, when you have questions at the end of this, you can just say, "David, could you answer this question?" 3 out of the 4 are named David, and J.W. Verret has agreed to be known as David for the balance of the panel. Our first speaker is going to be David Leitch. David is a graduate of Duke University and the University of Virginia School of Law, so he's hedged on basketball games in the ACC unless Carolina is playing. Thank you. He clerked for J. Harvey Wilkinson on the Fourth Circuit and then for Chief Justice Rehnquist, and served after some time in private practice, he served in the Department of Justice as Deputy Assistant Attorney General in the Office of Legal Counsel. He also held positions as Chief Counsel of the Federal Aviation Administration and as Deputy Counsel to the President when George W. Bush was in office. He's now General Counsel of a privately owned automobile company, Ford Motor Company. And we'll have a few things to say about the impact of the financial investments and bailouts on that industry. David Berenbaum is the Executive Vice President of the National Community Reinvestment Coalition. He is a graduate of Touro Law School and Stony Brook. He has been looking very hard at questions of how the financial bailouts affect funding for mortgages and for people who want to acquire property. He has testified in both the House and the Senate on how to fix our current problems, and he assures me that he has the solution for anything that is wrong with the economy today. Well, okay, maybe I overstate that a bit. David Zaring, our next speaker, is a graduate of Swarthmore and Harvard Law School. He clerked on the D.C. Circuit. He is currently an assistant professor at the Wharton School at the University of Pennsylvania. He has written extensively on international economic regulation and administrative law topics. J.W. Verret, David, is a graduate of LSU, the Kennedy School, and Harvard Law School. He clerked for John Noble, the Vice Chancellor of the Delaware Court of Chancery, and he can do equity if you need it. He practiced at Skadden Arps. He is a Cyril Kaufman Fellow at Northwestern and Assistant Professor of Law at George Mason University School of Law. And with that, let me turn it over to David.
Thank you. I'm going to stay seated if that's okay. Before I begin my remarks, I just want to make the obligatory statement that as the General Counsel of Ford Motor Company, my remarks here do not necessarily reflect the views of the company, the management of the company. Of course, I'd be disappointed if they didn't agree with them, but I'll let them speak for themselves on that. In describing the subject of this panel, the organizers of the conference gave us a little written paragraph on what they thought the panel ought to talk about. And the question, they said, was revolved around the basic regulatory model, which presupposes a private entity being regulated by a government agency. The new model, they said, has government owning some or even most of a private entity and exercising influence through both informal and formal mechanisms within the firm, while also having the traditional tools of regulatory control. They then asked whether this so-called new model presented special problems in figuring out how regulatory laws fit with those providing for investment, whether control will be more politicized and less transparent, and whether it changes the way courts should approach agency review, deference, or preemption. I'd like to focus my remarks on the premise that there is, in fact, a new model that is neatly contrasted to the basic regulatory model. To be sure, I quite agree that there is a basic regulatory model in the United States, as described, that of a private entity being regulated by a government entity. This model is at work in all of the classic forms of government regulation. To take an example that's close to home, Ford Motor Company, a public company in the traditional sense of the word, still a private entity vis-a-vis others in our industry, is closely regulated in terms of safety and fuel economy by NHTSA. NHTSA conducts traditional government rulemaking through notice and comment procedures. We participate through commenting, and it's the standard administrative procedure we've come to know and love, or at least know. So I don't take issue with the view that what is described as the basic regulatory model is in fact the basic regulatory model. What I do want to emphasize, however, are two very pertinent facts. First, that the basic regulatory model has always been subject to a variety of variations that blurred the line between public and private. And second, that there is in fact no new model, but rather a variety of different and largely untested arrangements that have resulted from the sort of ad hoc decision-making that occurred during the financial crisis of the past year. And it's the unbridled nature of that decision-making that I believe should concern us. Let me begin with a bit of history. Writing for the court in 1995 in a case called LeBron versus National Railroad Passenger Association, better known as Amtrak, Justice Scalia recounted the history of the government's involvement with entities that have the corporate structure. He noted that there is a long history going back to the first Bank of the United States of what he called corporations created and participated in by the United States for the achievement of governmental objectives.